Pluralism at URAC Research. I am moderating this webinar series, which has been organized with the support of the University of Verona, of the Institute of Federalism of Fribourg, and of also the Institute of Comparative Federalism at URAC. And this activity is also part of the activities of the IACL research group Constitutionalism and Societal Pluralism. Today we got an outstanding lineup of speakers who I welcome and thank again for participating in this really interesting webinar. Allow me to introduce them to you. The first person who will be taking the floor today is René Kuppe, who is extraordinary professor at the Department of Legal Philosophy of the University of Vienna, where he currently coordinates the program of Indigenous Legal Studies. Also, Professor Kuppe is a board member of the Commission on Legal Pluralism of the International Union of Anthropological and Ethnological Sciences, nominated member of the Committee on the Implementation of the Rights of the Indigenous People of the International Law Association, and member of the Research Center Human Rights at the University of Vienna. His specialized expertise in legal pluralism and indigenous rights will by all means enrich our discussion. Afterwards, the next speaker will be Michael Breen. Michael is a lecturer in public policy in the School of Social and Political Sciences at the University of Melbourne. He got his PhD at the Nanyang Technological University of Singapore, and then he was Mackenzie Postdoctoral Fellow at the University of Melbourne. His research focuses on federalism, political parties, and electoral systems in Asia, and also on the management of ethnic diversity and deliberative democracy. The third person that will be speaking today is Kyriaki Topidi, who is currently head of the research cluster on culture and diversity of the European Center for Minority Issues. Before joining the European Center for Minority Issues in 2019, she was senior lecturer at the Faculty of Law at the University of Luzern in Switzerland and guest scholar in many institutions all over the world. Her research interests are diversity management, minority protection rights and mechanisms, and human rights law, with a special interest in legal pluralism and religious diversity. And finally, the floor will be given to Professor Roberto Toniatti, Emeritus Professor at the University of Trento. Professor Toniatti is a leading scholar in comparative constitutional law, and his areas of interest are numerous and varied. We may summarize his decades-long academic work in three main lines of thought. Besides consideration on the comparative method, Professor Toniatti has focused his interest in territorial pluralism and regional autonomy, and on the different manifestations of pluralism. And Professor Toniatti will present his comment of the three presentation, taking the role of a discussant. And then some few words about the organization of the webinar. To begin with, I will provide a short introduction about the subject dealt with in this webinar series and specifically in this second event. Then there will be the three presentations that will last 20 minutes each or so. And afterwards, Roberto Toniatti will take the floor and comment on their presentations for around 10-15 minutes. Then the floor will be open for further discussion, and absolutely questions by the audience are warmly welcomed. Those who would like to participate in the webinar asking a question or leaving a comment may write in the chat tab, and we will be pleased to give them the floor. Also, written comments and questions are welcomed. We will collect them and pass to the speakers. So thank you very much for being here. And before leaving the floor to our speakers, as I said, allow me to say some introductory words about this webinar series and specifically this second webinar. With this short introduction, I would like to briefly clarify the meaning of the expressions contained in the title of the webinar series, and also state the aim both of the series and of this specific second webinar. As I explained in our first webinar, this series sets out to investigate the relationships between federalism as an analytical framework and what we may refer to as emergent models for the accommodation of diversity. These latter, among which we include legal pluralism, represent contemporary patterns of diversity management, which in a way and to various degrees diverge from the traditional minority rights law instruments and complement them. Somewhat they may be seen as the manifestation of the démarche of contemporary constitutionalism towards the implementation of its pluralist content. All these models, in fact, reflect the idea of diversity being a general and complex and dynamic phenomenon which characterize our societies on the whole, and not something that is only related to some recognized minorities. These models imply the inclusion of diversity in state organization through governance means, which empowers groups and communities. Therefore, they entail a major focus on a governance dimension, integrating the traditional paradigm of protection that underlies human and minority rights. These instruments challenge, in a way, the nation-state paradigm that underpins minority rights, generally implying the protection of national minorities. And it does so to meet the growing need and demand for accommodation of diversity. Indeed, on the one side, these instruments allow for a greater inclusion of many forms of diversity. And on the other side, they, to various degrees, deviate from the recurring structure of minority rights law instruments and the related idea of ethnicity and territoriality. In order to capture the trends and the evolution of the tools for the accommodation of diversity, in this webinar series, we use the phrase, the law of diversity, which is specifically intended to propose a unitary conceptual framework that reconnects traditional and contemporary perspectives in these fields. This expression indeed highlights that traditional and contemporary instruments are part of the same phenomenon, the legal management of form of social diversity, and specifically suggests that we refrain from framing diversity accommodation only through the lens of minority rights. In this series, we are focusing on three models. On our first webinar, we focused on participatory democracy. Today, we focus on legal pluralism, and the next webinar will be on non-territorial autonomy. And these models may be considered as emergent, although some of them as have ancient origins. Our goal in this webinar series is to look for theoretical instruments to frame these models, to explain them, and to foster their evolution. In fact, a theoretical recognition and explanation seems necessary for emergent phenomena to be better understood and to express their potential. And this is where federalism comes to the fore, as we will attempt to verify whether federalism may be employed as an analytical tool, as an interpretive paradigm, a lens through which it's possible to study these models. The basic idea is that federalism could be seen as a broad analytical framework for a large number of experiences. In other words, federalism may be read as a general notion, implying an essential logic, a method common to several phenomena, beyond its materialization in a form of territorial government. These proposed conceptualizations appear to be interesting because it may lead to exploding the theoretical potential of federalism. And in turn, This seems particularly useful and worth of interest because federalism, in a way, is the most structured and long-standing set of rules aimed at managing pluralism through governance means. Last time, Professor Palermo told us that in his view, federalism is the closest we have to a constitutional tool to manage pluralism. In fact, federalism has developed principle to manage the coexistence of various norm-producing authorities in the same political space. And for what concerns specifically legal pluralism, that is our today's subject, we will try to investigate whether the operation of legal systems that are composed of stratified normative legal orders could be deemed as expressing some kind of federal organization or logic. And as a consequence, we are focusing on whether their dynamics and underlying rules, as well as their developments, may be better explained or inspired by a comparison with the ones that occur in federal systems. In other words, we are interested in studying if a federal framing, which can also entail the use of a federal semantics, is a useful theoretical operation with regard to these phenomena. And as I told in our first webinar, this is a difficult and complex task. And I really thank the speakers that accepted to be in this webinar series, because this task requires us to distance ourselves from some well-trodden and reassuring conceptual categories concerning minority rights and federalism. However, this is not without its value, especially with regard to areas of research that are evidently undergoing a moment of crisis and redefinition. The intuitive connection between the field of minority rights and federalism are apparent. Our goal is to see if it's possible to go beyond them and to show their deep connections and their common ground consisting of the concepts of pluralism and governance. Research progress is the outcome of attempts and failures and of proposals and confutations. We are here to perform the most creative dimension of our activity and to see where it will lead us. So thank you very much for being here again and for participating in this webinar that touches upon really interesting, but why not also controversial theoretical issues. So I very much look forward to listening to our presentations. So without further ado, let me give the floor to René Coupe. Please, René. We will.
Yes.
We will start with his presentation.
Yeah, thank you. I try to open. I try to open my presentation. Yeah. Can you see it?
Let's see.
It should be open. Yeah. Can you see it?
In this moment, we can't see it.
Okay. Sorry.
No problem.
I was a bit surprised now because let me look. I made the opening of my screen. Did it open?
No, I'm sorry. Did you find the green button?
Yeah.
Okay.
I opened
it. You may have to let him be the co-manager of the meeting.
Yes, sure. But he already has the green button to share the screen, and we already tried also. But if there are some issues, maybe we can move on to another speaker and then try again if you want.
Maybe I try to get into the webinar again. Yeah, I register again. Yeah. So go to the other speaker, please.
Okay,
yeah.
I'm sorry.
Thank
back. You. Okay.
I'm really sorry. Yeah, I'm sorry for this. Yeah? Okay.
No problem. Okay, so let's move on to Michael Breen's presentation, whose title is Measuring Change in Federalism and Diversity Accommodation. Please, Michael, the floor is yours.
Okay, thank you. Can you see that screen?
Yes,
okay,
yes, perfect.
Excellent. All right, thank you very much for the invitation and opportunity to speak. As we were discussing before we started, it's a fascinating topic, and thanks, Niccolo, for the really insightful introduction that you gave as well. I was taking lots of notes. My perspective is very much from the federalism perspective, but using federalism as a tool to understand the accommodation of diversity. So there's I think a lot of links with legal pluralism. So I'll be talking about the conceptualization and measurement of federalism and accommodation in particular, and relating that back to some of the questions. So as was mentioned, my name is Michael Breen, and I am a lecturer in public policy at the University of Melbourne. So it's, I think, good morning to most of you, but a good evening from me here in Australia. My research has focused on federalism in Asia, so I'm going to give a few examples from Asia, in particular drawing on an approach I developed and applied to the cases of Nepal, Myanmar and Sri Lanka, and I continue to use and refine this approach for a number of other purposes, which I'll also give one or two examples of some broader applications. And I think this approach speaks directly to the questions that were posed earlier and in the concept note for this particular talk. So there are two ways, I think, to approach this. Moving on to the next slide. One is to talk about accommodation, and the other is to talk about federalism. And so I will talk about conceptualizing both of those, and then I will talk about my measurement approach, which deals with some of the criteria and things that you might look at for trying to understand legal pluralism, among other things. And then I will finish with some examples and some concluding thoughts. So first, I want to talk about the accommodation of diversity. So I adopt an approach to accommodation that follows some of the ideas from McGarry, O'Leary and Simeon, who are you probably know, prominent political scientists. And they distinguish between assimilation, integration and accommodation. These can be measured along a continuum. Now, this is, of course, not because we can't draw lines between these particular concepts, but because policies and laws can be more or less accommodating, and also, of course, can be considered as a package, notwithstanding that they are not often coherent packages. So under this type of approach, we have assimilation, referring to an approach that aims to erode private and cultural differences and build a common national identity. On the other hand, integration and accommodation both seek to respect cultural differences. Integration is defined as the privatization of national, ethnic and cultural differences and the predominance of individual rights and freedoms. And this approach is, largely underpins a lot of traditional liberal democratic approaches in the West. Integrationists would argue, for example, that the state should be neutral and that private or civil organisations are best placed to manage identity-based differences. So the state structures themselves wouldn't have, I guess, the legal pluralism, but in the social structures, you can see these different sources of law. And then accommodation is the recognition of diversity and its institutionalization into state and quasi-state institutions. Then we have federalism. Again, we have a continuum, but this time I think it's between federal and unitary. I follow an approach from Ronald Watts, and Ronald Watts distinguishes between federalism as a kind of ideology or normative principle and federal systems or federal political systems as the institutional manifestation of that principle or the outcome of the pursuit of that ideology. So as an ideology, we can characterize it quite simply as being about unity and diversity and shared and self-rule, or to use, I think, Nicolo's words, the existence of and relations among overlapping legal orders in the same space. I think that these are fundamentally the same principle. And there are fundamentally multiple polities, limited authority of those polities, and reciprocal responsibility amongst those. So I think that those concepts at this higher level really talk to each other. And I believe that it really helps when you take away that or make clear a distinction between institutional arrangement and principle. This approach can also get us away from the idea that federalism has to be about territorial communities, or have the Riker or Ware idea that there needs to be at least one area where there can be no override or intervention from one level of government to another. If you apply this kind of really strict institutionally based criteria, then you could argue we don't have federalism in places like Canada and India, which I think most people would disagree with these days. So federalism under those sort of conceptions is traditionally thought to exist or to not exist. If you look at a lot of political science comparative works, particularly those that use quantitative data, they simply code federalism as a 1 or a 0. So it's either federal or it's unitary. There's no in between. But we have an increasing number of hybrid states, and some of those are formally unitary, and some of those are formally federal, but they have really significant or substantial features from one or the other. And I put up a quote here from the former Chief Minister of the Northern Province in Sri Lanka. I'll read the entire quote. The classical distinction between federal and unitary states is giving way to more complex forms of nation states. There are states which are unitary mainly and federal mainly. There are states which are unitary in some dimensions and federal in other dimensions, and there are those which are neither. India and China are examples of these mixed characteristics. We cannot limit ourselves to look at the problem of devolution from a binary reasoning standpoint of unitary or federal only. But then we also need to take into consideration, I'm talking about accommodation earlier, the federalism is not necessarily accommodating, and it can be designed to be integrating or assimilating. So for example, Australia or the US federal system does not really have very much to do with accommodation of diversity other than to an extent accommodation of regional diversity. So we need to incorporate some kind of dimension of inclusion or accommodation. And this could perhaps incorporate an understanding of legal pluralism as a distinct dimension of federalism that can exist more or less in federal and hybrid systems. Just to go back to the Ronald Watts approach. So we have the normative element, and then we have the institutional arrangements. So you can have federations, and this is what we normally associate with federalism. But you can also have constitutionally decentralized unions, confederations, federacy, and of course, hybrids. So when we take this kind of approach and we distinguish between those, we can consider federalism again along a continuum. So how do we operationalize this? So there are 4 key features to the standard federation model. We have division of powers, bicameralism, an independent umpire, and usually territorially sub-national units. But you can also include many of the more basic institutional structures that further or impact the objectives underpinning the ideology. And they can, of course, be aggregated and disaggregated. And when I say we can add some other institutional things, we can add things that support federalism, or we can add things that speak more particularly to issues around the accommodation of diversity. So I mentioned earlier, of course, that federalism is not always accommodating. It can be integrating or assimilating depending on the design of federalism. So we need to measure that aspect as well if we really want to understand links between federalism and accommodation and the overlaps between those two. So for example, when we measure the provision of territorial autonomy, we also need to consider the extent to which that territorial autonomy is linked to ethnic autonomy, formally and in practice. So is it an ethnic federalism or a territorial federalism? And there is an important fundamental difference between ethnic and territorial federalism, or ethno-federalism, or multi-nation federalism, depending on what you might call it. And that is that territorial federalism tends to be based on the principle of legal neutrality. So everyone is treated the same, more or less, whereas ethnic federalism incorporates this legal pluralism idea both institutionally and practically. So we can design a set of indicators that can measure federalism and accommodation, incorporating the legal pluralism aspects, and then we can aggregate and disaggregate them to see how accommodating federal systems are, or the relationship between specific institutions and specific kinds of outcomes. So for example, I've got the key criteria that I have been using here. We have autonomy, talking about the extent of central authority, and the scope of a unit's autonomy, so the division of powers. Constitutionalism, quite fundamental to federalism, having a rigid constitution and an independent adjudicator. There is the interdependence in bicameralism, and when we're looking at ethnic relations, we also need to consider legislative-executive relations. How we think about the units I mentioned earlier. So are those units, do they actually have an ethnic dimension? Are they furthering accommodation objectives? Are they recognizing legal pluralism? This comes down to, I've organized this on three aspects. One is about the provincial level, the middle level. Then there's a special autonomy level, and also one that takes into account local government, because local government in ethnically diverse countries, such as Nepal, has this additional objective of targeting autonomy to smaller and more clustered groups. To jump to that example a little bit, Nepal has more than 100 different ethnic groups, and it made a decision to move towards federalism with one of its primary objectives of accommodating that diversity. But it is quite fundamentally impossible to use federalism to accommodate that diversity at the provincial level. And so one of the ways of dealing with that was to create a strong and constitutionally empowered local level of government. Then we can look at asymmetry, representation, so taking into account electoral systems, reservations, cultural rights. So is there observance of personal laws or family laws associated with religion, language rights? How are traditional authorities recognized or incorporated into the system? And then are they counteracted or counterbalanced by assimilative aspects, like, for example, enforcing a national language without recognizing other languages? And then I also look at the party system. And then so each of these can be tagged in different ways as being federal and accommodating, federal only, accommodating, and then you can create a range of different perspectives from which to analyze these things. So here are some examples. So this is Nepal, and what I've done here is I've actually created some indexes dealing with the accommodation and federalism, and used some other indexes as well, and track those over the period from the commencement of the modern state through to, I think this one goes up to 2016 or 2017. And then you can look at how they changed. And then you can also insert other sequencing or exogenous factors, and comparing countries in this way really gives you a good perspective to see what are some of the causes of change and the consequences of institutional change as well. So this diagram shows accommodation, and this incorporates the federal and ethnic dimensions of the indicators mentioned above, mentioned earlier. And it shows how the state's approach to accommodation has changed over time. In this situation, we're looking at the solid line. I'll come back to the dotted line a little bit later. And I've also included in this one a measure of internal conflict, which is the grey one coming down, as well as some of those sequencing factors, for example, economic crises, regime type changes, and major external or contingent events, like say a major natural disaster. It primarily deals with constitutional and legislative side of legal pluralism. So it's not the recognition, it's not accounting for informal sources of law or norms that might exist in particular ethnic groups, but which haven't been recognized by the state at this point. But I will come back to that briefly. So another example here is where I've mapped it for 3 countries, and you can see the comparison here. This one includes a trend line. So we have Nepal, Myanmar, and Sri Lanka. Interestingly, with Nepal, you can see a very strong upward trend, which has been maintained as it's institutionalized many of its recent changes. In Myanmar, the trend is upward, but there's a lot of fluctuation, and upward trend is because of the very large jumps over the last while. And Sri Lanka has seen a decline more or less over time. And this has been pronounced in the last couple of years, which actually aren't included in this graph. So you can see from this kind of historical, institutional, or path-dependent perspective, you could almost predict what might happen in some of these cases. Nepal was much more likely to institutionalize some of its arrangements, where there's been a decline in the accommodation in Sri Lanka, for example, over quite some time that has more or less continued. Here is another one where I have done federalism and conflict in 8 countries in Asia. And so this is where I use federalism very much on a continuum and looking at federal systems. And so these aren't all federations, and it includes countries that are fundamentally unitary but have really important federal features. For example, Indonesia and the Philippines, where they have constitutional decentralization and special autonomy. And on this one, I have compared it with democracy. So that's the, I think, polity index and an internal conflict measure as well, and aggregated those. So you can see pretty simply that there is a strong positive correlation between democracy and federalism. And this correlation continues even when you control for the conceptual overlaps between federalism and democracy, because you would naturally expect to see some correlation, because they each require things like, or generally have things like legislatures and independent courts and so forth. Also, it shows that conflict will tend to decline as federalism increases, and we can of course look at some of the particular causal variables for that, and or mechanisms, and do some, look at the individual country cases, and you can see some of the reasons for that relationship. This one, Sri Lanka, I wanted to show because my measurement approach also incorporates what I call informal institutions, following the language of historical institutionalism. So this is where you make a distinction between formal rules and organized practices, which may be informal and may not be recognized by the state. And it also includes or takes into consideration the extent or whether or not institutional changes were actually implemented. And so this is the dotted line here. So when you look at the broad accommodation institutions of accommodation in Sri Lanka in the solid black line, it hasn't actually changed that much. But when you look at it in practice, there has been quite a substantial difference in practice to how they're actually implemented. So I think that's also an important insight here. And here's just finally three examples, three of the informal examples, Nepal, Myanmar, and Sri Lanka, with the trends. Now, doing these sort of things helps us to understand when and why institutions change and the conditions under which accommodation of diversity is resisted or incorporated. So here I've used those cases to develop a conceptual model about why federal systems change, in particular about how you get the emergence of holding together federal systems. Now, holding together federal systems, which are basically all the modern federal systems since World War II, tend to be associated with ethnic division or ethnic conflict. So they will all tend to have this, this ethnic accommodation element to it. And so this kind of idea shows under what conditions the accommodation of diversity is resisted or incorporated. And then I lost my train of thought. I wanted to stress in this the role of infrastructural capacity. So you get the convergence of particular events with particular conditions. So both the sequencing and the timing of these things is important, but when they coincide, you tend to get these substantial changes. The infrastructural capacity relates to the strength of the minority ethnic groups. Now, I know we're trying to move away from minority, but this is an important aspect here. And so when those minority ethnic groups start to develop that infrastructural capacity to a higher level, this can goad central government and other potential allies to cooperate with them and to recognize those infrastructural capacities, or to recognize the legal pluralism as well of the different non-state actors or different ethnic groups. And so I think that this is, this is an example of one of the insights you can get from doing this measurement of and monitoring of change and the reasons for those change. And so I think that the response to that infrastructural capacity, the idea of which goes back to Michael Mann and some of his theories, and updated by Daniel Ziblatt along the way in relation to federalism. So I think that's a really important insight for how legal pluralism might come to be recognized and institutionalized in a federal state structure. So I will conclude with some tentative responses to some of the questions or thoughts that were posed. So about the relationship between federalism and legal pluralism, I believe that they overlap quite fundamentally when a federal system is ethnic and aimed at accommodation of diversity. And this is the case, as I mentioned, for most holding together federal systems established after World War II. And importantly in this is to think about federalism as one, not necessarily being tied to a territorial principle, and secondly, being able to be considered along a continuum, and so not being just about institutions and not having a firm distinct line between what is federal and what is unitary. Secondly, federalism is established or changed when ethnic minority groups achieve that certain level of infrastructural capacity and the state seeks to incorporate and recognize that legal pluralism. And indicators can be developed that can, of course, be aggregated to measure degrees of federalism, degrees of accommodation, incorporate legal pluralism, and then consider how it relates to state structures. And this helps us to determine the conditions of change and their effectiveness. And finally, emerging federal systems in ethnically divided and modernizing states give a window to the ways and reasons for recognition and institutionalization or resistance to legal pluralism. And there are a number of fascinating cases, I think, that could be further explored to this end. I've given examples of Nepal, Myanmar, and Sri Lanka, and I think pre-military coup in Myanmar, at least, there was some really interesting innovations about how you recognize ethnic diversity. And so there's a lot of empirical examples in Asia that I think are often neglected in the political science and perhaps law disciplines, and deserve a lot more attention. And I think the program that is being pursued here is one potential avenue into that. So that is all I have. I'll look forward to hearing some other presentations and any questions or discussions later. Thank you.
Wow, thank you very much, Michael. That was a really thought-provoking presentation. So many issues touched upon. What I found really interesting was the idea of federalism as a flexible model, as long as some basic principles or elements are respected. So the idea of go beyond some yardstick models that have been our first point of reference for a long time. Thank you very much. So let's move on to Kyriaki Topidis' presentation, whose title is Legal Pluralism as Federalism. Please, Kyriaki, thank you very much.
So good morning from Germany. Do you see the screen?
Yes.
Awesome. So as this panel, first of all, thank you for the invitation. I think this is a fantastic opportunity to do creative thinking collectively, so I do appreciate it. Then second thing, as a good comparative scholar, and since this panel has a good number of comparative scholars, I think I have to also disclose the fact that contrary to Michael, I think I would come to this discussion from the perspective of legal pluralism rather than federalism. So bear with me in that sense. And also, I also want to clarify a few things in advance. The first point is that from my perspective, and for the purposes of our discussion here, I understand law as an institutionalized and authoritatively mediated collective action means, which is essentially a social dimension of law, not so much, a very formal black letter one. The second, if you want clarification ab initio that I need to make is in terms of my understanding and expectations from the concept of jurisdiction, because we do, talk a lot about it, mostly indirectly, but I think it's also useful to clarify that for me, jurisdiction is a space, a site of contestation and a space for the articulation of norms that function, as alternative to, or even in resistance to sovereign power. And you also, I think, start to get my point about being a little bit critical about the way we should and can understand sovereignty. And then in terms of what I would like to do today is very cautiously try to explore the affinities between legal pluralism and federalism. I will do so in terms. I think I would begin first with federalism, then move to legal pluralism, and as a third stage, actually spell out what I think could be possible avenues in terms of overlap in the direction that you suggest, moving beyond obviously minority rights as a means, if you want, for the legal management of diversity. So allow me first to say this, that pluralisms in law are several. I was able to identify three broad types. One which is of cultural nature and which actually would lead us to discussions on multiculturalism, which are not necessarily ipso facto the aim today. But then there are two more that I think are essential for our talk today: the legal type of pluralism and then the constitutional pluralism, which are the ones that I think we will be trying to make talk to each other. With that said, allow me first to think a little bit about federalism and actually think conditionally about federalism in the sense that what kind of federalism could be the one that moves closer to legal pluralism in my mind. Obviously, a type that relies on the three important principles: the principle of superposition of the federal federated legal orders, one which encourages autonomy of these federated entities, and as importantly, one that emphasizes participation of the federated entities in the federal sum of it all. As importantly, I think that if we are to approach the two concepts, the two approaches, the two methods of management of difference, we should also understand federalism as political compromise, apart from the classical multi-tiered government structure and scheme. We should also emphasize, and I think René Coupé will take that upon his own talk, on autonomy, and an autonomy which entails institutional, procedural, but also guarantees, but also a respect for constitutional identity in the classical way that we would see, for example, in the method of subsidiarity, in the tool of subsidiarity. Then federalism, in order to start a dialogue with legal pluralism, I think should also have a telos, an aim which is how to accommodate ethnic diversity. Ethnic, cultural, religious diversity, if you want the full description. But here, relying on the key recognition of difference and diversity through shared governance. Lastly, but not less importantly, I think that we're talking about the kind of federalism that accepts that diffusion of power is preferable to its centralization. So this is more important than it sounds, I think, in my understanding, again, from the perspective of how do we bridge differences in multicultural societies. Now, let me offer a pluralist justification as to why federalism could be a very useful model when it comes to diversity management. First of all, because it can track cleavages on the basis of language, ethnicity, and religion, because it offers the benefits of the possibility for error correction, a robust field for norm articulation, and a space for creative innovation, to the extent, of course, that we choose a particular kind of federalism. And I'm reverting here to all the comments and literature and analysis made a long time ago by Robert Cover. I think federalism is also important in a legal pluralist framework in the sense of acknowledging the fact that there are more than one norm-generating communities with power over their actions, even if these communities are not a formal and integrated, constitutionally speaking, part of state law. So here, I think you understand that we're starting to move closer to legal pluralism. Then attention to cultural components, non-institutional factors, and power relation constellations, I think give the added edge to this type of governance, or this model of governance, or this toolkit, depending on how you understand federalism, in order to give us, if you want, a more efficient way to understand and accept and manage difference. Finally, I think federalism can also be a useful opportunity for multiple decision makers to be part of the process, so the participation element in the previous slide, with obviously the possibility that we would come, and we could come with better and at least more solutions, which depend on the legal context each time, because obviously I don't think I need to say that a lot of these models are highly context dependent. Now, how about the process of designing federalist tools for diversity? How should one, or how could one go about it? First, as I just hinted, I think we should see federalism as a process which leads ultimately to integration or differentiation. So the acceptance and the enhancement thereof, although integration, by the way, in minority studies is already considered, a passé term, we're speaking now of inclusion, of federalizing as much as a structure. So federalism works in two capacities: the structure, which is very well mapped and developed in literature, but also as a process, which I think is less well developed and also establishes already a good, a basis for it to dialogue with legal pluralism. However, if one is realistic, I think that designing federalist tools for diversity is somehow a difficult, if not impossible, aim, because we are asking a system to come up with answers as to how one can reconcile what has been so far, or mostly, depicted as a territorial form of governance with more universal principles and understanding. So how do we reconcile local variation with national, and also as importantly and more likely to become common, international and transnational forms of normative orderings? And I will come back to that later on with examples. What I also find interesting in this inquiry about how do we design, how do we adopt federalism for diversity, the concept of jurisdictional redundancy, which is something which is, I think, already present in international law, and it's already, giving us a hint as to which direction we should move on. Now, jurisdictional redundancy is a process where two legal communities claim that have both jurisdiction over an actor, and one of these actors agrees not to assert jurisdiction in exchange of the fact that obviously the other one will take action. A very characteristic example that I put down for you is the one of the International Criminal Court, which only prosecutes if home states refuse or are unable or unwilling to prosecute someone. So you see, where I'm trying here to forge a little bit of a basis for the convergence and the coming together of the two tools. What I also found interesting in terms of a pluralist reading of federalism is this concept and example of emancipatory federalism. And I would think that this comes very close, and this is merely a suggestion here, to a comparison and even a partial fusion with legal pluralism. I understand here emancipatory federalism as one type of federalism that respects the concept, but also accommodates self-determination of groups. One which is also flexible in its acceptance that it's necessary to achieve unity, but that will come at a cost, and the cost would be less coherence of a system. And here, in order for you to see how that works in action, I could think of the example of the European Union and how that construction works. It is based on flexibility, and for example, it is also largely asymmetric because there are a good number of derogations and exceptions. Then going back to the features of emancipatory federalism, I would say that we should also emphasize that constitutional unity does not mean uniformity. Again, a very commonly and widely discussed preset. And then when it comes to accommodation, I think here we should think of formal recognition of processes of the legitimacy of the demands of the minorities that happen to be, for example, the majority in strictly defined spaces. And that can happen at different levels. Of course, here the accommodation, the way I have phrased it, sounds territorial, but I don't think that we should limit ourselves to that. And if you refer to minority studies, you would see that there's already some basis, not very efficient always, and it comes in the form of sufficient demand being formed by members of groups. Then the other element that sounds to me appealing for our discussion in terms of emancipatory federalism is this thing called an inclusivity check. I will also come back to that later, but for now, I will just say that an inclusivity check entails the fact that the different actors involved in the running of the system actually make sure, or the state in particular, makes sure that all the voices, or as many voices, are heard when it comes to identity and accommodation and needs. And then finally, I think here emancipatory federalism has the final added value, which is to accept and understand normative claims which go beyond, a division of competences, which are specific to areas of social regulation. For example, family law. For me, that looks at religion, that is a very classical area, and which are obviously, as I said a moment ago, are not based on territory. And we're looking here at models of enhancing cultural self-government or political participation. Now, I'm turning to the other pillar of our discussion today, which is legal pluralism. For those of you that are not familiar with the concept, I think we're talking about a scenario which involves a multiplicity of legal orders operating in the same social field, and that happens beyond sovereignty considerations. In its descriptive form, legal pluralism includes political context, including within constitutional federal systems, but also the normative forces which are operated on the basis of actors and communities. So in other words, agency. The multiplicity here of jurisdictional powers that legal pluralism observes and analyzes can happen on federal terms. A very classic example of overlap is constitutional federalism. I will come to that in a second. Is consociationalism and personal law. The last one, to the best of my knowledge and understanding, is the one that provokes most questions, and it's also the one which is the more difficult to establish. So the affinity between that and federalism. The main difference in the literature, if you look and compare the categories of the two concepts between legal pluralism and federalism, is the fact that the division of public jurisdictional power is one way of envisaging managing difference, whilst in the legal pluralism context, you have a mixture of public and private authorities which decide and regulate and essentially participate in norm making and norm implementing as well. Then there is, in the context of legal pluralism, recognition by the state that non-state norms can be legally accommodated, and that involves obviously delegating or sharing power with them. Is legal pluralism a possible strategy for the management of difference? Well, I think we already have an understanding that it is. Otherwise, I don't see why we should be here gathering and discussing it. However, it doesn't come without, if you want, shortcomings. Why? Because it involves the demonopolization of one deciding what is fair and what is equal within a given normative system, as opposed to the aim of maintaining cultural differences. But for example, in the personal law scenario of legal pluralism, sometimes or very often, this delegation of, if you want, decision-making power to non-state authorities does create adverse effects, what we call the freezing of difference. And here, the example I'm alluding to is the one talking about religious communities, for example, and gender issues. So all in all, if I were to summarize what the implications of legal pluralism as a model for managing difference, I would say that we are moving from questions of legitimacy to questions of efficacy. And also in terms of more theoretical analysis, we are accepting that the extension of legal authority is inevitable in a plural, multicultural state. Now, I referred to the risks briefly a moment ago, but legal pluralism is also highly, if you want, criticized for the following. Because it's a non-public form of managing and decision-making, because it's unaccountable in public terms, and because ultimately, in many cases, it pushes in the scenario, if you want, that individuals or entire groups even are exempted from laws of general applicability, with whatever implications that may have in terms of fairness, equality, and even human rights. In terms of its effects, it also has a number of costs. It fragments polities, it privatizes public power, although if I am allowed to introduce an asterisk here, I think that this is where public law is moving into the future regardless. But anyway, it's not, so what I'm saying is not just legal pluralism's fault. It also comes at the cost of the reification of group identities. And also, if we talk about my more narrower field of interest, it leads to, you know, what I call the freezing of difference, the entrenchment of religious hierarchies. It does also create a very wide and vast field of conflict. Conflicts happen usually in terms of principles colliding. For example, liberal values versus liberal principles, very classic situation. And as far as legal pluralist literature has been debating all of these issues, vis-a-vis conflict in particular, we do have some recommendations for solutions, but I think that they're important, but not conclusive. I've put down in the slide one such suggestion that came more than, 20 years ago from Ayelet Shahar on sharing governance. For example, when it comes to the state and religious authorities, conceding a slice of public lawmaking in exchange for group members being able to self-determine and exit groups. But obviously, if you think a little bit about this, you will realize that for some communities, this is not a perfect solution because law has a reach and its reach is limited. And the question that one can ask, for example, in that scenario is, to what extent can the law regulate social processes? So outline shunning or ostracism when a member wants to exit his or her religious or cultural community as part of the deal that Shahar proposed. So by delegating law-making power to non-state authorities, implicitly, the state becomes also responsible or complicit or in agreement or in acceptance, if you wish, with violations of human dignity and fundamental rights. So this is the darker side of legal pluralism. Now, let me now try to move the two things closer to each other. What would be the benefits of legal pluralism for federalism? Obvious one, the recognition that multiple normative orders exist. Accepting, which is not a small thing, because that's, I think, the essence of our discussion today, that normative conflict is inevitable, but we have to put emphasis on how do we manage that conflict, not how do we avoid it. The focus on the dialectical interaction between these normative orders, so the state and the rest, if you want. And by dialectical, I obviously mean in both directions. The identification of ways that actors, and understanding also, that actors navigate through multiple fora, and I should add, have multiple identities, and they choose which identity to put forward depending on what they want to achieve, both as individuals but also as groups. The fact that legal pluralism is useful for the processes of international law development in particular. I referred earlier on to transnational jurisdictional assertions, to the way that norms are articulated and produced also by international bodies, to NGOs, to indigenous communities, to multinational corporations. I mean, think of the way that content moderation online is being developed. It's not just a dialogue between states. It's a dialogue between states, companies, private companies, and so many other actors. So legal pluralism allows us to get the feeling and an understanding of what is already happening, I guess, in some fields of law. Jurisdictional messiness is the cost, but we should also see the silver lining in this. It does promote windows of opportunity for more dialogue among the different levels of governance, with the possibility for more, but not the guarantee, I should add, for more inclusion and tolerance. Perhaps in the medium to longer term, that's more manageable and more achievable. And then the other implication is the remodeling of sovereignty. What is legitimate? How do we exercise authority? Where do we draw the lines? Classic, I think, questions that federalism has been asking itself for a long time. And then final, the acceptance, and I think that's very important, that no statement of law is final, that this is a process and this has to adjust to the needs and the types of claims put forward in terms of managing difference. Now here, what I've done in this slide is to give you an example of something which is already, if you want, accepted as a mild form, relatively uncontroversial, where federalism and legal pluralism can and do overlap. Here, the combination of the two is happening along the following terms. You have a state which is to be blunt and honest, a collective fiction based on the belief in its existence, but which carries, which is institutionalized through norms of laws, institutions, and administrative action. The acknowledgement that within federalism there are multiple sources of sovereignty authority, but that there are simultaneous and, if you want, multilateral forces between legal actors involved. The cultural dimension of statehood, that is something that I think we tend to neglect many times. There is a connecting dimension here between federalism and legal pluralism. And for example, I could think of this question: how do we usually negotiate the national dimension of identity? It is a very different process if you do it in a legal pluralist, philosophy, as opposed to a very strict, unitary state configuration. The aim is shared between constitutional federalism and certain forms of legal pluralism to enhance inclusive procedural mechanisms of institutions to develop further dialogue and cross-jurisdictional collaboration. And finally, they have commonalities, which can be listed as follows: emphasis on systemic spaces for dialogue, possibility for contestation, possibility for negotiation, and reflection on procedural tools towards consensus. So a few further examples that scanning the literature I could, group here for the purposes of beginning a discussion. We already have proposed solutions when it comes to federalism and legal pluralism governance. These are subsidiarity schemes, spaces for local variation, hybrid participation agreements, jurisdictional redundancy, which I already mentioned. So these are the few, the ones that you will, I think, find relatively easily if you go through the existing literature discussing the two models. One example that comes often forward is the concept of EU federation or confederation, as was shown in the previous presentation, although this is heavily contested in terms of, the label federal, for several reasons. I've listed a few of them for you here. And then there's also the other side of the Atlantic, which is giving us some food for thought. Although there is a federal supremacy in the principle in the American model, there is at the same time a practice of federalist bargaining, where you have negotiations between competing sovereign agents, and these negotiations can take and have been taking several forms. They can be political negotiations. They can even become go all the way to formalized methods. And I did find one example of a particular, if you want, outcome of such a process. But then I think more importantly, apart from the isolated few cases, we can also start to think about this element of negotiation a little bit further and refer to negotiated federalism as a possible model that, brings the two models, legal pluralism and federalism, closer to each other. Why? Because it provides opportunities for multiple stakeholders to participate in governance and policy making. And it also alludes very strongly to what in legal pluralist literature you will find as described as normative, inclusive, dialogical processes. This kind of negotiated rulemaking is described as follows. You have interest group bargaining and stakeholders and the state agency work together, producing content towards administrative regulation relatively early in the process of rulemaking. So they don't make the rule, the state doesn't make the rule and then test it on different communities, as is usually the case, but they start earlier on together. Why is that attractive? Because it creates clearer final regulations, because it has the chance or the possibility of including fewer technical errors, also possibility and high chance of quicker implementation if more than one actors are involved, also greater compliance. But of course, it's again not if you want, fault-free. It does raise questions of proper representation, of transparency, and the fact that, very simply, I don't think that all matters can be the subject of negotiated rulemaking. And I've listed one example, which is fundamental rights. And then the biggest risk of it all is, what do we do when there is no consensus? if the actors, the stakeholders in the state agency cannot agree on the final outcome. So it is very nice to say that a negotiation can and should be a constitutionally legitimate way of deciding, but ultimately, again, in realist terms, I think the system itself or the aim of the management exercise, the difference management exercise, is standing before an important dilemma, which is this. Do we prefer to risk deadlock, or do we prefer the failure to consult? Now, another thing that I thought would be interesting, and again, I'm moving backwards here, is to put down a list of questions that the federal decision maker should include in his or her deliberations and agenda setting, if the state agency, let's say, is to be labeled as pluralist. And I think these questions are the ones that demonstrate how close the two systems can be. And by two systems, I mean legal pluralism and federalism, certain kinds of federalism. So the first question is, what are the normative systems at play in a given context? So essentially, what is really happening? What kinds of processes are happening? What is the systemic, for example, violation, when patterns of violation, when we talk about minority rights, are they intersectional? How do they happen? The second question, which is an important question because it's a balancing question, is should I, as the state, restrain my voice and let others speak because they know better or they understand the situation better? Is there some other decision maker that can speak to the issue more appropriately? Can hybrid decisional frameworks be useful to bring more voices to the table? So this kind of negotiation / flexibility, so the combination of the two. And how do I design in constitutional terms ongoing practices, procedures, and arrangements, which I think is the bit which comes probably towards the end of such a process when you're trying to put together rules and principles that pursue the aim that we have set from the start. Now, in terms of conclusions, this is my penultimate slide, so I'll be soon done. When we attempt to bring legal pluralism and federalism together, I think we can conclude at this stage the following: that there is no normative order that does not draw some basic lines of inclusion-exclusion. That's unavoidable. I think it's all a matter of proportion and justification. Second point, there are emerging global legal orders that work both ways. They come from the bottom up, but also from the top down. And this, if we are to bring the two systems together, we should acknowledge those and understand how they work. Third point, legitimacy is a political argument, but I think as importantly, a sociological point of contestation. Think of social movements and minority protection. There is normative desirability of the normative desirability of legal pluralism is not universally accepted. It's heavily criticized, as a matter of fact. But federalism, I think, as a system that permits the tensions and conflicts to be played out in the jurisdictional structure of the system can be very useful. So here I'm reverting to the mode as to what legal pluralism can learn from federalism. And then if we are to bring the two together, I think we have to accept that there should be an agreement in the variations of both models, an agreement as to participation, that participation is essential in the common enterprise. Final points, a legal pluralist reading of federalism is appropriate for certain areas in particular, the internet, indigenous people, and global environmental challenges, just because they are transnational and their effects are, for good or bad, beyond the national context. The quest for best law should combine here dialogue, but also self-restraint. And we have to also acknowledge, in terms of medium to longer term planning of the effects of diversity management models, that the long-term effect on procedural and institutional design challenges will be different if we introduce elements of dialogue and self-restraint and negotiation. It will make the process flow and change ultimately. And then my very final point is an understanding and an acknowledgement that values of pluralism cannot always trump over community values. And I came across two different examples, very different between each other. There is literature on child marriage and federalism in sub-Saharan Africa that shows how, for example, federated entities block the application of international laws that the federated union of a particular state has already accepted. Or you have the opposite example from the Canadian experience, which since the 70s, the mid-70s, engages, in order to avoid the kind of scenario that I just described, engages in a process where the ratification or enforcement of international human law provisions and commitments happens through consultation and negotiation with the various federated entities. And it is precisely to clear the space and avoid the divided competence issues on what matters most in our societies. I think I'll stop here and thank you very much for your patience.
Thank you very much for your intriguing presentation. Really, it was really interesting because you built so many bridges between legal pluralism and federalism, also with concepts that emerged also in the last webinar. So the importance of the concept of participation as a bridge that actually bridges federalism and the law of diversity. And it's really interesting the way you put you pointed out so many fundamental issues, and the thing, some models, some positive and negative points, but also the idea that federalism makes us focus on many important concepts that in a way or another can apply to models for the law of diversity. So thank you very much. Let's move on to René Coupe's presentation. Let's see.
Yeah, I hope it works now.
Yeah.
Yeah. Can you see my screen?
Yes.
Fine.
Yes.
Okay.
Fine.
So
cool.
I was a bit worried, and I will open it completely. This. Okay. So it should be
okay.
fine.
Yeah, it works.
Okay.
Yeah. Thank you.
So first of all, thanks for the invitation. I was really very stimulated by the possibility to talk about this topic. My own approach to this topic is very much based on my experience with legal pluralism, and particularly in the context of Latin America. In Latin America, generally, the relationship between state and indigenous peoples as an emerging subject of the law is not considered as an issue of federalism, but nevertheless, I wonder if federalism could be used as an analytical concept to understand the kind of association between official state systems and state political units and another level that is generally defined as indigenous. Nevertheless, there are not only indigenous peoples falling into this second type of political level. This also can be Afro-American communities and other local people. So the basic issue of this seminar is how to relate federalist systems with legal pluralism. And I admit that at first glance, a lot of overlaps in the meanings of both do exist. I hope I can. Can you see this? I would really like to take this away. Okay. Anyway, the two superficial parallels are that federalist systems are coexisting and somehow coordinated levels of self-government, while on the other hand, legal pluralism means that, or at least there's an understanding that there exists a parallel of non-generating communities, mostly each with particular cultural backgrounds. At least this was the original idea when the term legal pluralism was created by authors like Hooker, who wrote a very important book on legal pluralism in the colonial context. So the idea was more or less there is the official colonial law, state law, and on the other hand is what he called customary law of native peoples. So the connection between one sphere of law to the state and the other sphere of law to a kind of an ethnic background was very implicit in this original meaning of the word legal pluralism.
I'm sorry, Renee, you have to turn on your mic. Thank you. We don't hear you.
Sorry.
Okay.
I don't even know why this happened.
No problem. Now it works.
It works. So my approach is to start from two relevant examples. So it's a bit a complementary contribution from my side, more to focus on two empirical examples, also from the consideration that sometimes the phenomenon of legal pluralism in the particular Latin American context is not very well known outside of this particular region. I will start with one case referring to a region in Mexico in a very violent state. It's one of the states with the highest level of killing and of violent conflicts. It's Michoacan. You can see it on the map. And I will refer to an indigenous people who is the most important indigenous group in Michoacan, the Purépecha, living in a mountain area in the northern part of Michoacan. The story on which I will talk started in 2011 when there was a mobilization of an indigenous community that is called Cheran. And this case is very famous, both in the Mexican political life as such, but also in academic analysis of this case. It's not a unique case. It's not a very isolated case. There are very similar cases, and therefore it's a good example to show what has happened and what has inspired the development of legal pluralism in Mexico. Actually, local people from this community were blocking the entrance of trucks, blocking the roads of trucks that are loading and transporting wood. And the local people were also the local police was also disarmed because the people said they are in complicity with organized crime. And so the local people erected barricades to prevent the access to the town, to prevent the entry of organized crime. And even the activity of the local police, of the state police, was forbidden. It was the beginning of an important bottom-up social movement gaining control over lands and autonomy in local affairs. What was the background of this situation? It was a response to economic and social developments that were initiated from the outside. Since the 1990s, the community forests had been transformed mainly into commercial avocado cultivation for the Mexican, but also for the international market. But the incoming avocado planters were related to organized crime, what is also called narcos, the drug dealing, illegal agriculture, and all these phenomena had entered into these lands and also had destroyed the environment of these people. The people found a recourse in their discourse to a long history of self-defense and social conflicts with the outside world. A long history that even was going back to the Mexican Revolution at the earliest part of the 20th century. the self-defense movement of the Purepecha people was directed against illegal logging. And when this movement had started, it even coincided with the state electoral calendar. So there were upcoming elections on the local level of political authorities. But the people from this region, the Purepecha people, decided not to participate in elections through the official political party system. That is a very important aspect. So it was not just a self-defense against environmental destruction, against organized crime, but also what they called a kind of self-defense against the political system of Mexico as such. And in 2012, the uprising culminated in the formation of a communal government based on what's called in Spanish usos y costumbres, uses and customs in English, and defined as the implementation of the people's right to self-government. On the one hand, there's a reference to so-called old customs, it was not even called customary law. It was called in Spanish usos y costumbres. That has a very long meaning in the context of Latin American history, because the same term was used in the colonial time with reference to Aboriginal customary law, as we could call it today. But it was not called law. It was called usos y costumbres. But on the same time, it is now defined as the implementation of the people's right to self-government. And this discourse, this level of reference to self-government is influenced by developments in international law, especially by the fact that Mexico had ratified ILO Convention 169, also by debates in Mexico on the upcoming standards of indigenous rights, especially in the meaning of the UN Declaration on the Rights of Indigenous Peoples, but also inspired by national reforms. And these national reforms about 20 years ago were very weak. Actually, indigenous rights, according to Mexican constitutional law, are always based on the recognition by state law, and state law means by the different federal states of the Mexican Union. So indigenous peoples only have rights when these rights are exactly defined according to the Constitution of Mexico by state law. But the Purepecha people, like other indigenous peoples in Mexico, were saying we are implementing our own rights independently of the recognition by the Mexican state, and especially with a more broader and completely different understanding that the state would give to the content of our rights. And there, of course, is well known, there are very similar movements in other parts of Mexico. Much more famous, it was the uprising of AZLN, of the Zapatista so-called Liberation Army in southern Mexico, that also had a lasting influence on the political life in Mexico. But there was also, interestingly, a resolution of a special court of the Mexican Federation that recognized in another case the right of indigenous peoples that the elections on municipal levels, on the local level of the Mexican state, would be in accordance with the uses and customs. So there is one decision saying that indigenous local communities, or to say it more strictly, municipalities with indigenous majorities, have the right to develop a system of self-government based on uses and customs. In other words, not based on the general local government system that is similar to most local government systems in other states of the world, with a participation of political parties, with a majority voting system, and so on and so on. So finally, there was even a recognition by Michoacán state law, by this federal unit of Mexico, of the right of indigenous communities to elect their own authorities according to their own rules. So I don't want to go into details. We also have, I think, very limited time, but just to give you an idea, the community elects a 12-person council with an indigenous name, and is organized based on different what they call campfires, that are small community councils of smaller neighborhoods. And there is even a schedule elaborated by these indigenous people themselves, showing the most important aspects of their self-government. I cannot go into details. You see that most of the functions, or all of these functions, have indigenous terms, and you do not find easily correspondence of the meaning of these terms in English or in modern political science. The most important concept in the Purepecha language referring to the government is Shura Mukwa. And the translation, according to an indigenous expert, is release by the mouth the command. This is a very special way of expressing what government means. Release by the mouth a command. And the meaning of this is that it should be a form of government that from the Purepecha social ethics perspectives gives meaning to the horizontal relationship of governors and governed. So there is no difference between governors, between a higher level of governing bodies and the rest of the population who are governed. The most important aspects of this system of Shura Mukwa is that it should be the exercise of people participating in this government system to give the domain of spoken public discourse. So there should be a kind of a convincing rhetorical intervention that all people share the decisions of the community. It's not a one-sided imposition of decisions and orders by the government. Releasing by mouth a command, that is the way how it is expressed sometimes in Spanish, managed to circulate the word. So the word shall circulate between all participants in the community and convince others to carry out actions in favor of community life. That's an important aspect. So the decision should be done in favor of community life and not in favor of particular political purposes. Shura Mukwa is a form of government that has its own normative system linked to the idea of living in harmony, and they call it today sometimes vivir bien, according to another idea that was created originally in South America, but now has also influenced the political discourses of indigenous peoples in other parts of Latin America. And it is a kind of living in harmony with Ireta, as they call it, the community of living beings. So a community not only in the political sphere, but also with the other living parts of the world, plants, animals, and the whole environment. And this idea was, on the one hand, based on the traditional worldview of these people, but also based on the experience to defend the forest against this incoming organized crime. This is very important to understand this particular background, how these ideas developed and not just were used in a kind of a specific defense movement, but also influence the development of a specific form of government, of self-government. So central is the forest, and the forest gives meaning and symbolic unity to this ireta, to this community of living beings. So an important aspect of the Purepecha government has been, as I said before, the development of protection against organized crime. So instead of accepting the state police, and the state police was also said as being complice, being itself involved in organized crime, the community created its own community security bodies. And these are substituting the municipal police or even the state system of public security. And you see these people and they look very martial. No? I really I'm a little bit shocked by the security forces of these people. This is the way how they are presenting themselves, armed and really a very strong symbol of power. But even if they are looking so dangerous, the experience in the last couple of years have been very positive. According to a community activist, this form of direct democracy and development of their own security forces has not only saved the forest or the rest of the forest, because a huge part of the forest had been destroyed, but brought peace. According to one official source, Chiran, this community in 2070s had the lowest homicide rate in the entire state of Michoacan, and perhaps even in the entire territory of Mexico. So the success of this development of self-government was very, very, very clear. Yeah? It was very positive in the view of these people, but also according to objective criteria. So I just want to get rid of these pictures. It was possible to develop kind of new institutions directed to these purposes, and also based on the one hand directed to these new challenges, to these new situations, but at the same time these institutions are the result of a history and of various cultural conceptions of autonomy within the Purépecha community. So they are not strictly old customs, they are the response to a new situation. They were the response of these dangers of deforestation, of organized crimes, of very recent phenomena, but at the same time, they made a reference to cultural conceptions of autonomy, also of self-government. So you see these old pictures showing the old, in some way, in a romanticized way, the old life of these people, but facing the current situation of a very violent everyday life in Mexico. And it's very important to say that all these developments are based on a bottom-up social process. This was not a recognition as such by the state. It was not the creation of autonomy law or of a federal system by the state. It was a bottom-up approach, a revolutionary situation that could be settled in the years after this situation, about 10 years ago. And it's not only created by the people themselves, it also has a normative structure, a way how it works, a way how it functions, that is based on principles completely distinct from the law of the state. I think this is a very important aspect. It's not just another kind of federal unit, it's really a system based on principles that are completely distinct from what we associate with the so-called modern liberal state. But nevertheless, the Purépecha never addressed the issue that they would not consider themselves as part of Mexico. On the contrary, they see their fight as a contribution to a more just society, to a more democratic society, to a more pluralist Mexican society. So this particular situation is not seen as a kind of secessionist aspiration or something that is separate from Mexico. It is seen as a contribution by these people to the Mexican reality. Now I want to go to another example in Bolivia. And Bolivia is in some way distinct because it recognizes by a new constitution from 2009 indigenous and ordinary jurisprudence to be on the same hierarchical level. So the idea of this so-called plurinational constitution is to create a state system where two levels of, or not two levels, two different legal realities are defined to have the same standing on the same hierarchical levels. So there's not a lower level of indigenous jurisdiction and state law, but they are defined as having the same standing. And we will see how this idea has been realized in a specific context, in a specific conflict situation. This was an interesting conflict in an Andean community that's called Songo. You can see it here on the map. And Songo has a long anti-colonial tradition. The community, the existence of the community goes back into colonial times. I think it was called Zungo Ayllu during the colonial time. It was surviving the independence from Bolivia during the 19th century. And in the course of the Bolivian agrarian reform in 1952, there was even introduced and developed a syndicalistic form of organization, like in many regions of Bolivia, the so-called Central Agraria de Songo, that was superimposed on the communitarian structure. So we have a kind of a community structure that is based on agrarian law from the 50s, but is somehow also mixed with the traditional community structures going back to the colonial time or even to the Inca time before the arrival of the Spaniards. The community was welcoming a mining project in the 70s because of the typical promises going hand in hand with mining, job creation, development, improvement of quality of life. But the work of the mining company in the territory of the Songo community turned into a nightmare. There were very soon strict and very strong labor law violations. People were ill-treated, were even beaten when they did not work as the mining company supposed them to work. And there was a lot of environmental pollution and even personal attacks against people who were claiming their rights. There was an extraordinary meeting of this communitarian body, the Central Agraria de Songo, in the year 1990, an expatriation of the head of the mining company from the community, but the resolution was not implemented. The reaction of the head of the mining company was against threats, criminal charges for presumption of office, and so on. And there was even issued a police arrest warrant against traditional authorities. So the state interfered in these conflicts on the side of the mining company and did not support the indigenous authorities. But the traditional authorities of Songo developed a new strategy. They said there is a lack of jurisdiction of state law in this whole issue. That was very new. That was a really groundbreaking idea to say we will not claim justice at the state. We will not go to state institutions, to state courts, or to the police, because Bolivia recognized now our own system of law, and it has the same standing within Bolivia like state law. And so, according to the logic of the recognition by the plurinational constitution, there was even made a decision by the plurinational constitutional court finally, saying that the responsibility and competence for the communal authorities is in the hand of these people, on this case. And finally, very recently, there was a declaration of invalidity of the state mining concession by the municipal authorities of Songo. So the Supreme Court of Bolivia recognized that the decision of the authorities of Songo even can be enforced against the concession of a mining company. That is very interesting because it means their decision, their communitarian decision is valid even in or against a state law-based mining concession. The Constitutional Court of Bolivia ruled the organs of the plurinational state of Bolivia have to participate in the enforcement of the decisions of the communal justice, and the communal authorities' cancellation of the mining concession is valid. In other words, what the community did was even relevant for a concession that was issued by the state mining ministry. And this shows that this is not just an internal matter, but a decision-making power that transcends the sphere of internal government of these people. The community celebrated its victory and see it as a contribution to the building of a plurinational state. So what are the implications of these two cases?
I'm sorry, René, sorry for interrupting you. We are running out of time.
I know, it's a little bit...
I'm sorry for that. Maybe, would you mind finishing in 2 minutes?
Yeah, I think I'm really ready. I'm really...
Okay, cool. I'm sorry for interrupting.
Very soon I'm ready. I think the debates on legal pluralism and federalism are very fundamental. Because general federalism refers to a system where several governments are combined in a single political system. The origin of federalist systems is seen as the association of self-governing political systems. However, it is generally supposed that these systems in some way are working in a similar way to modern political institutions. In our two cases, we could see that the self-governing units existing within the nation state are building up another kind of legal institution from the bottom. Both in the case of, I want to jump over, this is a citation from the famous article of Griffiths on legal pluralism. But when we take serious what he says, that legal pluralism is based on the strength of the self-regulatory activities of another system, we can take serious what the poor Petra have done. They have established a communal government, and their decision-making, their communal government is based on unanimous agreements in the search for solutions for the common buen vivir. So it's not based on state law, it's not based on the philosophy behind state law, it's based on their own worldview, and it's completely different from the state law logic. And in the case of Songo, we see that the legal system of the self-governing unit is not limited to its territorial space. The self-governing unit is even competent and relevant for external persons if there are convincing connection criteria. So the limits of the self-governing unit cannot be strictly defined by a certain social group. There is no association between legal pluralism and certain social groups. According to the logic of the plurinational state, non-state units are not private actors, but public, albeit non-state bodies. Nevertheless, in our case, the non-state units do not even accept the defining element of the modern democratic state, political parties. So this also shows it's a logic that's completely distinct from state law. And I wonder if we can really correlate legal pluralism with the general idea of parallel self-governing institutions, yeah, because there is not an overlap between both. Maybe we can discuss it in the last moments that we still have. I'm really finishing now. Thank you for your attention.
Thank you very much. That was really interesting and enriching. These two case studies, in a way, if we frame them through a federal lens, can be framed as examples of new layers of decentralizations in federal state, and or the creation of federal space or layers that do not correspond to classical ones, but maybe follow the same logic. So thank you very much. There will be a question for you afterwards. I already see it in the chat tab, but let's give the floor to Professor Roberto Toniatti for his comment on the three presentations. Thank you very much. The floor is yours.
Thank you very much, Niccolò, and I would like to thank you and the organizers for inviting me to play the role of discussant, or which I very gladly perform. First, because I found very fascinating the hypothesis that was introduced as a presentation to the series of webinars. And secondly, because I really think I have been privileged in listening to the presentations this morning, and I would like to underline the fact that each one of them had its own very different approach from one another, and yet all of them and each one of them contributed in a very enriching way to deepening our understanding of the topic. I really have to be very brief because we are short of time, but still I would like to say make some general statements which ultimately are, I would say, within the proper role of a discussant. Now, first, I would like to start with the colonial origins of the concept of legal pluralism. Now, Professor Kuppe has mentioned that already, but I would like to repeat it in a different framework. And the framework is that at the colonial times, legal pluralism was a concept elaborated in order to give body to social separation, to the separation of communities, obviously separated according to a hierarchical structure. Now, the power of defining legitimacy and distinguishing the legal rules applicable to the distinct social and cultural segments of the population imply the hierarchical structure. Now, I would say that in federalism and in what I anticipate, I think may be named cultural federalism, there is no hierarchy. And this is important because if we are talking of instruments for dealing with the management of the diversities, we have to keep clear in mind that pluralism always entails respect for the dignity of all the components of the pluralism we're talking about, be it social or cultural or linguistic diversity, as each diversity is a diversity in relation to a benchmark, but by itself is an identity. And from this point of view, it deserves to be treated with full respect and dignity. Now, in colonial times, the cultural cleavage was especially a cleavage between and among different legal traditions, as Patrick Glenn would define them, or legal families. In particular, civil law, and the colonial countries were France, Spain, Portugal, the Netherlands, and the common law. Now, civil law and the common law in the origin of legal pluralism were all distinguished from chthonic law, exactly as Patrick Glenn would call them. And in other words, we have here a cleavage between the world of rationality versus the world of holism, of holistic cultures that combine the constant interaction between man and nature, between present, past, and future, between natural and supranational. I think that the example that Professor Kuppe gave us on the concept of Yuramukwa and the concept of Ireta, the community of living beings whose symbol is the forest, is very clear from this point of view. So here we have two worldviews whose mutual compatibility is hardly to be achieved. And we have to distinguish the Weltanschauung of state law, which is based on rationality, and non-state law, based on holistic foundations, as in chthonic law and I would say also on religious law. Now, in Europe, even before the French Revolution, holistic beliefs that are at the bottom of chthonic law disappeared. Perhaps, I say perhaps because I don't know enough about it, are part of the Sami culture, are part of the Roma and Sinti population's culture, although the latter are to a large extent assimilated. And since the American and French revolutions, the same happened with religious law. In other words, the historic trajectory has been the one of state law erasing non-state law, so that the Western legal tradition has achieved the monopoly of legitimacy in legislating, in setting the rules. In other words, a system of legal monism. why do I want to say this? Because I think that the emphasis should be put on accommodation of diversity and normative pluralism. Normative pluralism distinct from legal pluralism. And how do I put them? How do I put the two of them together? Because state law, state legal monism expresses normative pluralism as they share the same method of lawmaking, whether it is international law, supranational law, or federal law. It is the political method of lawmaking, which is quite different from the method of lawmaking of religious law or chtonic law. A plurality of legal settings mutually compatible on the shared ground of the method of lawmaking. I say this because when we try to compare federalism and, let's put it this way, when we try to compare territorial federalism and cultural federalism, we have to start from these very basic distinctions, considering also that territorial federalism does indeed have rules breaking the conflict of laws. The Supremacy Clause in the United States. In Canada, the Supremacy Clause, but when it comes to protection of fundamental rights and freedoms, you have the notwithstanding clause of Article 33, which allows provincial government to suspend for 5 years, if I remember correctly, provisions of the Canadian Charter. In the European Union, we have Article 51 of the Charter, which establishes the primacy of EU law to member states only when they are in the field of application of the law of the European Union. Otherwise, member states being free to enforce their own rules, even incompatible with those of the European Union. And mind you, this area is an area which refers to fundamental rights, but in particular, divergences in family law, in minors law, in issues of morality of individual behavior having public relevance. So that even in Europe, from this point of view, and perhaps in Canada, we might have to refer to cultural cleavages that introduce values of religious law into state law, which may be the embryo of some sort of cultural federalism, mainly regulated as an individual space of autonomy. Let me add also the phenomenon of agreements between the state and religious minorities in order to regulate the status of those minorities within the state legal system. You have these in Italy, you have these in Poland, and the same in Spain. And this perhaps is also a manifestation of a sort of, and I repeat, a sort of cultural federalism. I apologize for advertising a forthcoming book to which I participated on such kind of agreements with the religious denominations. And on the chapter which I wrote on Italy and Spain, I speak of consensual legal pluralism, which may be an element of building this sort of cultural pluralism. The fact of the matter is that in the rest of the world, legal pluralism is much more present, certainly in Latin America, as Professor Cooper has said, but in Asia very much as well, and in Africa. In Europe, this affects, I would say, a fundamental change in paradigm, a shift from an equal and uniform citizenship to a cultural and diversified citizenship, which is something that we see already with regard to language minorities in Italy, for instance, or in Spain or in Finland. I don't want to take too much of your time, but at the same time, I think it is important to draw a distinction between legal pluralism and hybrid legal systems. Now, let me show you this map of a research project of the University of Ottawa, where you have here a classification of mixed legal system, mixed or hybrid. And here you have a combination of civil law and common law, civil law and customary law, civil law and Muslim law, common law and customary law, common law and Muslim law, civil law, Muslim law and customary law, common law, Muslim law and customary law, civil law, common law and customary law, common law, civil law, Muslim law and customary law, civil law, common law, Jewish law and Muslim law, and or Muslim law and customary law. Now, this is a very impressive elaboration, and of course, mind you, there is no Asia and no Latin America in this research, at least so far. So we should expect more varied outcomes in the future. Now, what happens is that Europe as well has to deal with the issues of claims of legal pluralism as a consequence of the global village, of the mobility of individuals and groups over various parts of the world. Of course, we have to draw the attention to the fact that there is another difference between legal pluralism in a strong sense and in a weak sense, which is important because it shows to what extent people are willing to go through sanctions and penalties for the sake of securing the observance of their own laws, in many cases religious, but in some cases customary as well. Now, let me go to the very final points of my comments. First, I think that we had very interesting presentations based on generalizations and mainly legal theory. I would suggest to have a different approach and try to have a comparative and to apply the comparative method to legal systems already existing in order to draw some affinities and commonalities and see how much they may be explained through the tools of federalism. For instance, the French system and the legal arrangements in New Caledonia. You may say New Caledonia is very far away. And yet the legal pluralism that is respected and established there, it has its roots in the constitution of the Fifth French Republic. The whole millet system in the Middle East as a relic of the Ottoman Empire, which is enforced not only in Northern Africa and Western Asia, but in Western Asia by Israel. We have the case of the territory of Aceh in the Malaysian Federation, where by choice of the population, Sharia law is enforced also in the rules of criminal law. The same in the Mindanao Islamic region in the Philippines, although the situations there is quite tribal. Again, I think it might be interesting to try to frame the enforcement of tribal law as distinct from Indian law in the United States, where tribes are under the protection of the US government. And I wonder to what extent one might try to apply the tools of federalism so that in the United States, you might have sort of two parallel federalisms, one territorial according to the federal constitution, and one personal or cultural. Now, the idea of cultural federalism has been deepened by a Spanish historian of law, perhaps Professor Coupe knows him, Bartolomé Clavero, who has insisted very much on non-territorial federalism and cultural federalism, with the implication of transforming also the legal system to a large extent into a system of personal law. And yet I have some questions. Although I would say I would endorse the approach of employing the tools of federalism to analyzing pluralism, and in particular legal pluralism, I still think that a number of issues have to be taken care of. For instance, how to identify the speakers on behalf of the distinct units of government for the cultural non-territorial units. How is the group or the tribe or the community organized, the IRETA of the Michoacan state, the community of living beings? And again, what are the limits to cultural self-government? Now, for instance, I appreciated very much when Michael Breen distinguished between assimilation and integration and accommodation, accommodation being defined as recognition of cultural differences. And here I have a question mark. Are there limits, systemic limits to accommodation, to the recognition of cultural differences? Has been made, reference has been made to child marriage. Is child marriage recognizable? Can it be part of accommodation? Again, a fourth question, a third question. Do cultural units participate to the government of the whole? That is, what is the quota of shared government? Again, is there an umpire in charge of deciding controversies? Is there a supremacy clause, as we have seen, does exist in territorial federal systems? I would also suggest to explore a different avenue, which is the one of the reflective judiciary, the composition of the judiciary mirroring social, cultural, religious differences in society. We should remember, of course, that the constitutions of South Africa and Zimbabwe made it necessary to appoint judges according to the fragmented fabric of society. I really enjoyed very much the approach followed by Kyriaki Topidi in stressing the fact that federalism is highly structured and yet it needs governance, whereas what Bartolomé Clavero would call cultural federalism is fairly unstructured and perhaps even more requires governance. Very lastly, I would say, would anybody of this group engage himself or herself in the task of writing a model constitution of cultural federation? I would say that Kyriaki Topidi's presentation would be a very valid guide to such an enterprise, because her presentation was not only creative, but creative in details, something which is not very frequent. Normally, creative presentations are very broad and general, whereas hers has been very accurate in details. And as I say, it offers a track for trying to write such a model constitution of a cultural federation. So thank you very much for your patience, and thank you again for inviting me.
Thank you very much. It was really interesting, and it is worth it to to run a little bit late to listen to all these presentations and on the comment from Professor Toniatti that who raised some theoretical basic issues that is fundamental. He suggested important avenues for research, and third, he also took into consideration some important questions to be addressed in further research that in a way that they are inspired from this federal perspective, that are all questions that inspired from federal dynamics, the idea of the empire, do cultural units participate to general government, and so on. This is what federalism maybe may help us in this research. I know that we are already late, but there is a question coming from by the audience, and I guess it's worth it to leave some space to the audience, and even if we are kind of abusing their patience. So from Christina Murray to René Coupe, there's a question about, she was wondering if there are examples of climate change being fought through customary law systems in Mexico, to your knowledge.
I must say, I cannot say it in relation to Mexico, but I know there are cases from Australia, especially there's one case pending, a complaint by an Aboriginal group. I think it was introduced in a court of a European state, but I cannot say it now immediately. That was actually based on what they call the Aboriginal customary law, that it violates their life in a very general sense, not only the landscape, but the argument is when you destroy nature, you destroy people. So there's an interesting argument relating genocide with ecocide. Yeah? That is now a very current topic in indigenous legal arguments, to say destroy nature, to destroy the people. That is very important now in Brazil, against Bolsonaro, against the Bolsonaro government, but also in some other parts of the world. This is what I can say. And this is founded in the indigenous worldview, relating human beings with other parts of nature. Yeah. It's also a good example to show how traditional worldviews are combined with modern ecological thinking. No? I wouldn't say the only source is tradition. It's also the argumentation, the context of modern ecological thinking. Yeah. That combines here.
Thank you. And I was wondering if there aren't any other questions by the audience. If you would like to react just quickly to Professor Toniatti's comments, Kyriaki, Michael, and René, in this order, if you would like to jump in.
If I have to go first, I don't think that I have any, immediate reaction. There's a lot of food for thought. I'm very, very much intrigued to see how we can push this forward. I'm particularly interested in the concept of cultural federalism now. After listening to him, I think that clearly, I don't have anything valid to say at this point, but introducing values of religions into state law as an embryo for cultural federalism is definitely the bit from his criticism that I would take up and pursue. Thank you.
Thank you.
Yeah, I also don't have anything in particular to add. There's a lot of as Kyriaki said, there's a lot of food for thought and a lot of really interesting things presented, which I need to give some more thought to. But I'm quite the issue of cultural federalism and non-territorial federalism, I think, is really, really important, and one thing that I've been trying to incorporate into conceptions of federalism. You don't need to rely on this territorial principle. So I do think that needs a lot more exploration. And also, I think across several of the presentations, all of the presentations, there was this emphasis on the legal pluralism coming from the bottom up, And so I talked about it in terms of infrastructural capacity, and as a big part of Renee's talk, and then how that can get recognized in these kind of federal institutions. And I think that that's an important process that also deserves more attention. But it's been, really, really fascinating presentations and comments, and I have taken a lot from it, and I'm really appreciative of the chance to talk and to hear some of these perspectives. Thanks.
Thanks a lot.
Yeah, I must say I was so impressed by your presentations, and some of the aspects of your presentation are very new for me. So I really have to admit I have to digest it a little bit. I'm not so familiar with, especially with the terminology of federalism research. For me, it would be interesting to explore how existing federal systems, that are very often just federations of state units or of quasi-states, quasi-sovereignties, working on the level of Western law, on the Western liberal state. So take an example, Nunavut in Canada. It's a very famous example of even accommodation to indigenous rights, to the Inuit living there. But Nunavut is a part of the Canadian state. Nunavut is not Aboriginal law, it's not Inuit law. Nunavut modifies a little bit the framework of state law for the needs, for the cultural needs of the Inuit population, like Alto Adige is Italian law, adapted to the needs of the German and Ladino-speaking population in South Tyrol, in some way. But it's not the law of Tyrolese people as such, and it's also no need for this. But in the case of indigenous people, it's distinct. The more important aspect of legal pluralism in relation to indigenous peoples is to strengthen their own institutions. So how could an arrangement like Nunavut or Greenland, that are very often considered as the best examples of adapting state law to the needs of indigenous peoples, how can really be found a combination with what I mean when I speak of bottom-up legal pluralism? That had not happened, really. And there was a big expectancy. I was even doing research when Nunavut was established, but now there's a big disappointment by many Inuit. They say there's even more mining and more implementation of Western development models, even if Nunavut is considered as an indigenous, as a part of a federal system. So that's, but it's an open question. And I would really like to be in exchange, an academic exchange with you.
That will be great, and it's absolutely interesting. This reminds me of the literature that addresses the idea of indigenous people as federal actors.
Yes.
For example, in the Canadian federal system, in fact. So I think that we abused too much of the patient of our audience. So we have to put this webinar to an end, and that was really, really interesting and intriguing. I want to thank you all for participating and for your patience, and thank specifically our speakers and our discussant. And I hope to see you in the next webinar that will take place on November the 16th at 5 p.m. I'm sorry, Michael, again, that will be in the night for you. And we will continue our exploration on the relationships between federalism and the law of diversity, and in this case, between federalism and non-territorial autonomy in its many shapes. So thank you very much, and have a nice day, and see you next time. Thank you.
Thank you.
Thank you.
Thank you.
It was a pleasure and an honor for me.